Hey y'all. Just wanted to share with you because I know everyone's really curious about how the new 5-year rule, the change up from the 15-year rule when it comes to past relevant work and how that can actually play out in real life at a hearing. Okay, so I had a hearing today. It panned out. I mean, it played out. We don't know the results of the hearing yet. It was a more difficult case, an under 50 person, with more of a limited but very chronic and severe injury to a limb. Okay, so here's what happened with the way the steps were taken in a sense of how it would normally work. So when the denials occurred on initial and recon, they looked at the last 15 years, of course, because that was when that rule applied, right? In the beginning of the hearing, the judge wasn't asking any questions. He was having me do all of the direct examination. So, which is not uncommon. I'd say it's like 50-50 whether a judge likes to do it and then we follow up with additional direct, or if, they just want the attorney to do the whole thing. So anyway, so my first inquiry was, well, does a vocational expert need more details about the prior work? And that's when we got into, and I said, oh, and the prior work, I think it would just be this one company because prior to that, it was before the 5 years. So we were looking closely at the dates, believe it or not, because that job, the only job that occurred in the last, so like what's now, it's July 2024. The last job started August of 2019. Okay. And so then technically the question would be, in theory, did the prior job prior to that, did that occur in July of 2019 into August, or was there a bigger gap in time? In this case, there was a sufficient enough gap, it didn't matter. Then, so now we just have the one job instead of, it would have been 4 jobs. I was prepared though, if they were going to be looking at that most recent job, only because we didn't have a definitive date in the record. Anyway, so the funny thing is, and we've talked about this in other videos too, that most recent job was technically titled a supervisor, it's like a supervisory foreman in a construction arena. And as such, as some of you might know, supervisory skills can be deemed to be transferable skills, so that even if you couldn't do your prior job, if you could transfer those skills to a different job they say you could do, you would be fine, in terms of at least that being a skill you could use for a new job. Not good for a case. So on the fellow's work history report, there was no indication of supervision, and I wasn't there for the initial part of it, but there was some reference to the title being like supervisor of construction site or something like that. So that concerned me, because I wanted to make it clear that the 8 to 10 hour days are hands-on, lifting 100 pounds, doing this construction work, and not spending full-time supervising workers. So it turned out it was more of a supervising of making sure X, Y, and Z are done at the construction site overall, and it wasn't like a massive construction site of a big, huge building or anything like that. It was these are small, local establishment. So, but the supervision is always where they can knock you off of your no transferable skills. And because this would normally be an unskilled type of labor. So again, going back to it with the 5-year rule, this is another, aside from the fact that it booted out those other jobs, here's what else it did. The person started in August. That job ended in November due to layoffs. That's 3 months. Because it was supervisory construction, it was considered SVP. I think it was 7. That's a pretty high skilled mental skills and such within that industry position, that you would not be able to argue would be an unskilled job if it's considered past relevant work. So fortunately, and SVP 7 takes much longer than 3 months to become proficient in those skills. That's the beauty of the SVPs when they start getting high. If you only did it for a few months before that 5-year period scrolls into year 6, then it won't count. And that's what happened here. That is not considered now. That whole job is not considered. Well, the construction worker stuff arguably would, because that part of the job is, well, it was like semi-skilled. So I think it was like a lower level, but it wasn't like a 1 or 2. But the supervision is a higher skilled thing that takes more time to, under the law, become proficient in and have gained the skill. So because he was only there for 3 months, never gained the supervisory skills that would be transferable, even though that was technically his job. The other argument I would have made if I had to, but I didn't have to, was getting into the nitty gritty about, well, how much of the day are we actually supervising these other people? You know, like these 4 or 5 other workers on the scene. Because if it's the type of thing where in the beginning of the day, you make sure they're all there and I go, you go to section A, B, D, and then you round them up at lunchtime when you have lunch and go, everyone doing okay? Okay, boom. Now back at the end of the day. All right, everybody, everyone got their parts done. What do you got left? Okay. If it's a 10-minute a day supervisory checking in, I would argue that that's not full-time supervision work. And for that reason would not be in past relevant work. I would make that argument. Didn't have to here because of the fact that he was only there for 3 months, not the requisite amount of months that the vocational acceptance of, time period on the job would be required to become proficient. That was where that saved that. Now, that doesn't mean that we prevailed, because we still have to prove that the person cannot do, and an under 50 person, you all know how arduous that is, cannot do any kind of full-time job, whether it's sedentary, light, medium, heavy, above. We have all those jobs to knock out. I feel like we did the best possible job that could be. The claimant was very, very frank and candid about what's going on. I thought he made it a great witness. So we'll see what happens when we get the decision. Don't know when that'll be. Could be anywhere from a week to many months. Usually we see him in 2 to 3 months, I'd say. Yeah, about that. But that's not by rule. That's just by habit. Okay. Past performance of the judges generally, but definitely not all. Okay. So that was I wasn't really foreseeing every little nuance that would come up, but as they were coming up, we had to like smack them back and, a little badminton going on. And the judge was very, very nice judge, respectful, listening, all that. There's, again, it's one of those kind of cases where, you just don't know where it's going to go. Although I was happy to see, a very listening judge who was, taking it to heart, but it doesn't mean we prevailed. So fingers crossed for us on that one, guys, just as we cross our fingers for you and everything else. I will talk to you later. I hope that was informative. Bye-bye now.